The clear and present danger reporting, that mechanism was established by Illinois law in 1990, and it was expanded incrementally to include school administrators as well as law enforcement over the years. Now, this law is distinct from firearms restraining orders. That became law in 2019. Clear and present danger is a mechanism used by the ISP to revoke or deny a firearms identification card. That's essentially the firearms permitting process that we have here in this state. Now, on the other hand, the firearms restraining order is a court ordered restriction on firearms possession. Clear and present danger status is only one of many factors that can result in the revocation and denial of a FOID card in the state of Illinois. Other factors can include, of course, criminal records, mental health prohibitors, and other types of orders of protection. So, upon the receipt of a clear and present danger report that's submitted to the Illinois State Police, officers will determine if the subject of the report has a FOID card or has a pending FOID application. And then they'll review all the information that's submitted by the local reporting department. So, for a clear and present danger determination, the legal standard for review ISP must meet is a preponderance of the evidence. Now, that's a higher legal burden than probable cause, a term that's been used several times throughout this process that I think everybody's familiar with in terms of the legal burden law enforcement has. So this is a higher burden of proof. That's preponderance of the evidence. Now, granting a firearms restraining order, again, that's distinct from a clear and present danger. That requires an even higher burden of proof, which is clear and convincing evidence. So I hope that's clear, and we'll repeat that, and we'll provide a written description of that further if there's any confusion about what that is. So if the reviewing officer determines that there is sufficient evidence to establish a clear and present danger that's posed by the subject of the report that came into ISP from a local law enforcement agency, then the subject's FOID is revoked or a pending application is denied. Now, if there's insufficient evidence, and that does happen, the status of the FOID or pending application is unaffected.
Hey, if you like that video, be sure to subscribe to our ABC7 Chicago YouTube channel.